Good morning, sir.
Thank you. Good morning.
Good morning. Good morning.
So let's start today's session. First of all, my introduction. Myself, Dr. Jaivir Shah. Qualifications are B Mechanical, ME Automobile, PhD, and Indian Patent Agent. My Indian Patent Agent number is 3339. It's very simple to remember. 3 plus 3 plus 3 is equals to 9. My first question is, are you comfortable in Hindi? Or is there anyone who are not comfortable in Hindi? Please give me an answer in chat box whether it is comfortable for you to conduct this session in Hindi. I do not have any kind of response. Yes, Neeraj, you can unmute yourself and ask a question. Yes, Neeraj, please.
Yeah. Actually, I don't wanted to ask any question. I just, gave the answer that you were asking. Like, we can go both way, like in English or Hindi.
Okay, sir.
Okay.
Let's
Thank
see
you.
that. Okay. So section 1 and section 2, which I am going to cover today. And how I am going to cover that is the most important thing that is required to be answered. See, when you are reading a patent act book, when you are reading any material, what is your main objective, or what should be the main objective of a person who is preparing for the Indian Patent Agent examination? The purpose is to crack the examination. So when I was appearing for the Indian Patent Agent examination, at that time my thinking in that direction only, and at that time I had prepared certain notes. It might be possible that you are not able to see that because of the green screen, but the notes will help me to crack the examination. And notes means what? Notes means crux of the things which is written in the Indian Patent Act. So this crux I am going to deliver today. So मैं सिर्फ इतना कहना चाहता हूं कि आज के लेक्चर में आपको फर्स्ट हाफ सेशन में, यानी फर्स्ट 25 मिनट्स या 30 मिनट्स, जो भी मैं लिख रहा हूं या जो भी मैं कह रहा हूं, whatever I am saying, whatever I am conveying it to you, you need to note it down. आपको वो नोट डाउन करते रहना है. मैंने सिर्फ और सिर्फ इंपॉर्टेंट पॉइंट्स ही निकाले हैं, सिर्फ और सिर्फ इंपॉर्टेंट पॉइंट्स ही निकाले हैं. आपको वो नोट डाउन कर लेने हैं, और after 25 or 30 minutes I am going to have a small quiz of 30 questions. So if you are able to give answer of those questions, then I think the purpose of whole section 1 and 2 lecture is delivered. Okay, so let's start with the section 1 and 2, and then at the end of the lecture, if you are having any questions during the session, you can also put it down in the chat box, and we will discuss it at the end of the session. Let's start with the Indian Patent Act, section 1 and section 2. Section 1 is a short title, extent and commencement. This act may be called the Patent Act 1970. It extends to the whole of India. It shall come into force on such date as the central government may, by notification in the official gazette, appoint, provided that different dates may be appointed for different provision of this act, and any reference in any such provision to the commencement of this act shall be construed as a reference to the coming into force of that provision. Generally we are reading in that manner. So one thing is, you can translate the language into Hindi language. That is the one way to read the Indian Patent Act. But ये जो हम read कर रहे हैं ना, उसका कोई question नहीं बन रहा है. और जब तक if you are not able to create question out of it, then you might be feeling that you are not comfortable or you are not having a grip over a patent agent examination. So this is एक एग्जाम्पल था आपके लिए कि मैं इस तरीके से नहीं पढ़ाने वाला हूं आगे. So this is the only first slide that I am putting, that I am not going to read in that manner. But what I should do now, my real part or real mentoring started. Okay, so 3 टाइप की रीडिंग मैंने आपको बताई. एक जो पर्सन डायरेक्ट रीडिंग करते हैं, दिस इज कॉल्ड डायरेक्ट रीडिंग. सेकंड इज ट्रांसलेट एंड रीड. So the translation of the part which is very much difficult to understand, that is also given here, and one can understand it easily. But the third thing and the main thing that one Indian patent agent need to do in order to crack the examination, or those who are appearing for the examination, they need to do is create questions out of it. How to create questions? How to create questions from this particular statement? So see, here it is written, it shall come into force on such date as the central government may, by notification in the official gazette, appoint. Okay, so ये कभी भी फोर्स में आ सकता है. इट विल बी कम इनटू फोर्स. सेंट्रल गवर्नमेंट जब भी कहे तब ये फोर्स में आ सकता है. करेक्ट. तो मैं अगर आपको कहूं कि रिसेंटली जो हम इंडियन पेटेंट एक्ट पढ़ रहे हैं, अभी जो हम इसको स्टडी कर रहे हैं, वो कौन सी डेट से अप्लाई हुआ है या एंडोस हुआ है, फ्रॉम विच डेट द करंट इंडियन पेटेंट एक्ट 1970 is amended, or which year? Can anyone know that answer? Exact answer of the date and year, please write down on the chat section. Thank you. One reply will be there. 20 April 19. That's cool. That's cool. Okay. Can anyone having this date, can you recall this date? 23/6/2017. Have you ever surfed ipindia.org website? Just check it out. If you are able to do so, just check it out, and whatever the Indian Patent Act given over there, just check out those that the final amendment or the final the draft which is provided on the Indian Patent in ipindia.org website, that is on the date of 23/2017. You got me? How to create question? Are you able to get the way I am going to teach you? If yes, then say thumbs up in the chat section.
So may I ask something, please?
Yes, sir. You can put it down in the chat section, and we will discuss all the questions at the end of the session, and I will give you the proof if you want such kind of proof holding.
Okay, sir.
Who is there? Yes, Sandeep, otherwise it will take some more time. So that's the meaning, nothing else. First I will complete my lecture, whatever I have prepared, and then we will discuss something. Okay, let's go for this second part. Thank you very much. Okay, so I need to cross check it out. Okay. So section 2 is the definition part, correct? And the first definition is appellate board. In the appellate board, what one should remember, That appellate board is given in which section? Appellate board relates to which section? Can anyone give the answer? So that I can know what kind of. Sir, please
Section
tell us
1,
again fourth point of the first
116.
section. Yes. Okay. The fourth point of the first section. Sonam Yadav. Just a minute. See, here it is written that provided that different dates, कोई भी different dates may be appointed for different provision of this act. यहाँ पर कोई भी amendment हो सकता है और different dates दी जा सकती है. And any reference in such provision to the commencement of this act shall be construed as a reference to the coming into force of that provision. और जहां पर भी नई डेट दी जाए तो वो डेट से ये प्रोविजन लागू किया गया है ऐसा माना जाएगा. उसी का ही मैंने ये जो पढ़ने में जो डिफिकल्टी हो रही है ना, in order to solve that difficulty I translated it into Hindi. That is the way of learning of Indian Patent Act. But the thing is you need to remember dates from the first section, which as I have mentioned in the example. Okay, let's discuss about the appellate board. Appellate board यानी अपील करना. अपील क्यों करना? क्योंकि अगर हो क्या रहा था, अगर इसको समझे ना तो हो क्या रहा था कि जो पेटेंट के जो भी क्लोजेस थे, पेटेंट के जो भी ऑब्लिगेशंस थे, जब वो डिस्ट्रिक्ट कोर्ट या हाई कोर्ट के सामने रखे जाते थे, then the technicality matters. So in order to take the decision, judge required one technical member, and then he can give some conclusion on that point. So in order to reduce the time of justification, to give justice to someone, the appellate board is constructed. अगर ये स्टोरी आप समझेंगे तो आपको समझ में आएगा कि appellate board क्यों कंस्ट्रक्ट हुआ. अब appellate board जो है वो ऑलरेडी ट्रेडमार्क एक्ट में अवेलेबल था. इन द सेक्शन नंबर 83 ऑफ द ट्रेडमार्क एक्ट, सेक्शन नंबर 83 of the Trademark Act 1999. This is the first point. Okay, I think someone has given the answer of my questions, that sir, for the benefit of non-Hindi participant, as far as possible stick to English speech. When you speak in Hindi, cannot make out of that. Okay ma'am, I will do that. So the appellate board is constructed just because to give justice in a proper time for the obligations which are created due to the patent. So high court is I can say, I am not saying it is unable, but in order to justify the decision, in order to come into the conclusion for the patent obligations, it will take some time if you are not having a technical member. So judge require a technical member, high court or district court, and then he or she can give the decision. So in order to reduce such time, such board is construed, and this board is construed as per the it is established under the Act, Trademark Act 1999 under section number 83. You need to write down this much only. कि appellate board means appellate board is established under 83rd section of the Trademark Act 1999. Okay, and it is mentioned in the section number. It is mentioned in the section number 116. So this is the information derived from the section number 116. If you read the Patent Act 1970, you will find out that the appellate board is refers to section number 116. But in section number 116, what are the information that are very much important? That is, the first thing is appellate board is established under 83rd section of Trademark Act 1999. That is the first thing. Second thing is the qualification, or who can become a technical member of the appellate board. So the qualification of the technical members are 5 years of controller. So if someone is controller, in which all the examination persons and all the patent agents are working, so 5 years as a controller, or 5 years completed 5 years as a controller, then if someone is patent agent having 10 years of experience and he pursues BE degree, engineering, bachelor in engineering, or patent agent with 10 years of experience has completed masters in not the bachelor degree, means he must not pursuing the bachelor degree, he has completed the he or she has completed the bachelor degree. So with bachelor's degree in engineering with 10 years of patent agent experience, one can become a technical member of the appellate board, and with the degree of master in science with 10 years of experience, one can become a member of the appellate board. Or if someone has served as a 5 years as a controller, he can become or she can become a technical member of the appellate board. Is it clear? So this much information that you required from the appellate board as far as concerned. Is it okay? Any doubt? In a chat section. Means whatever I am teaching, you are having any doubt in it? Means right now appellate board, as far as appellate board is concerned. If no doubt, then thumbs up. Can you repeat 116? Yes, this is 116, section number 116. What to be remember from the section number 116 is appellate board established under 83rd section of the Trademark Act 1999. And who can become a technical member of the appellate board? Those who have completed 5 years as a controller and 10 years as a patent agent with bachelor degree in engineering and 10 years as a patent agent with master degree in science. Yes, Muralidharan ma'am. Muralidharan ma'am, either sir. Sorry. Sir, which came first, Patent Act or Trademark Act? Okay, that we will discuss, because in order to give the answer of this question, you need to give me the answer of the Madrid Convention or the Berne Convention. If you are having the knowledge of it, then it will give you the clear-cut idea about which act is formed for which purpose. Okay, but your answer is very much simple, I think. If you are recalling the Indian Patent Act and the number of year, then you can definitely define it which act is come first. But our concern is appellate board. As far as appellate board is concerned, are you clear about this fact? Yes. Okay, thank you. Let's talk about the another definition. It is assignee. Now, assignee, what do you mean by assignee? It's just like a nominee. When I remember this part of assignee, the term, at that time I recall it as a nominee in the bank account. So suppose I am a bank account holder. Now see the glimpse or the charm of the thinking or charm of the correlation power of a logical person like you and me. Okay, assignee means nominee in the bank. Okay, suppose I am a bank holder, a bank account holder. I am not a bank holder, I am bank account holder. So my wife is my nominee under my bank account. Okay, now if any case, if the person is deceased due to, suppose the bank holder deceased, then who will be the assignee of that particular thing? My wife. So my wife can again represent or put one assignee in that particular clause. So assignee means the assignee of the assignee or assignee of the deceased person, and he can or she can also appoint one assignee. So जो भी main holder है, those who are the main holder, main person, he can put some assignee in behalf of it. So that is the main definition of the assignee. So assignee is not at all a legal representative. If you are thinking in that manner, then you are thinking in a wrong direction. Assignee is not at all a legal representative. Legal representative means after the death of that person, the direct owner of that particular property, of that particular document, that is called the legal representative. And legal representative, if he or she nominates someone on behalf of him or her, that is called assignee. I think the assignee part is very much clear in your mind. Assignee is the assignee of the main person, or those who are holding the main patent in as far as the Patent Act is concerned. Okay. Yes, assignee can be anyone, but it must be assigned. True. But there is a clause. Okay, so I will ask you, I will give you all the questions, and I will ask you a certain number of things meanwhile in the lecture. So hypothetically, if the assignee is no more and there was nominee appointed, what will be happen to patent, to that patent? See, that's why the whole assignee concept is there. That the concept of assignee is when the number one thing is, if someone is putting patent from the America or something out of some part of the world, and he assigned that particular task to someone or to some person, so on behalf of that assignee, that person can do all the legalities or all the work that is required to be done in that particular nation. So that is the one function of the assignee. Second thing is the assignee of the deceased person. Suppose that person is anyhow, due to this such circumstances, if anyhow the death of that person is happened, then the legal representative will become the owner of that patent, and legal representative again put one assignee on behalf of him or her. So that is the main part of the assignee. Okay. Third part is how many persons will be the part of the appellate board. As far as the Indian Patent Act is concerned, it is written. So this is the first time the question which I am come across, that the how many persons will be the part of the appellate board that I am heading. But as far as the Indian Patent Act or section 116 is concerned, it is not mentioned clearly that how many persons will be the part of that appellate board. Okay. May assignee a company? Yes, it can be. Assignee can be a person. Even though legal representative are not assignee by virtue of principle of justice, correct? I think that really cool. That's if I'm getting such number of queries and such number of chat, that was really cool. But I need to complete first my preparation, and then I can give you the answer of such questions. I want to read each and every statement which is posted by you, and I would like to reply it, but with few seconds, please, with few minutes, sorry, not seconds. Okay, so I'm closing just chat box. So Budapest Treaty. Now the Budapest Treaty, under which section? Section number 10, Budapest Treaty will be there. And what should we remember in case of Budapest Treaty? It is related to microorganisms like bacteria. Yes, bacteria can be fermented, and if that process is developed, that can be come into the patent, that can be drafted in terms of the patent. Next, capable of industrial application. So what do you mean by capable of industrial application? That can be used by the industry. That can be whatever written in the patent, that must be able to produce, or I can say reproduce from the patent. That in that manner the patent has to be written. It must be non-obvious to the person, but as well as it must be the capable for the industrial application as well. because the three criteria of the patentability, what it defines: novelty, non-obviousness, and industrial capability. So capable of industrial application is also the part of the patentability. Are you getting? I think I'm going very fast. Please tell me, please put in the chat box that what are the criteria for the patentability. Do you know the three criteria of the patentability? Patentability. What do you mean by patentability? The basic three requirements of the patentability: novel in nature, novelty, okay, non-obviousness, and instead of usefulness, usefulness is also correct, but we can it is particularly mentioned that it must be capable of industrial application. Yes, capable of industrial application. So that part, capable of industrial application, the third part, is relates to which section? Section number 2 under section 1, subsection 1, and under that subsection 1 the part is AC. See, suppose such kind of question is asked, how you are going to remember this AAC? See, here it is also AAC and here it is also AAC. So that's why in that manner you can remember that. Suppose it is asked in the examination that industrial capability comes under which section, the answer is section number 2, subsection 1, and under that AAC point, that the industrial applications come. Okay, let's move forward. There are so many definitions are there. Controller comes under the section number 73. Controller means control everything. Right now I am controlling this class, so I am the controller for that particular Zoom meeting. Okay, so in that manner, all the examiners, all the patent agents, those who are working under whom, that is called the controller, and that may be appointed by the government. That is written in the section number 73. It having two clauses, means controller and board member, but the controller is defined in this section, subsection 1 of the section number 73. So remember section number 73 as far as controller is concerned. Okay, and that is appointed as per the subsection 3, section 3 of Trademark Act 1999. Why I am saying this? Because I have gone through the papers, I have gone through the previous year's papers, and I found that such kind of questions asked in the examination. See, you may feel that it is written in terms of Trademark Act, but why it should be asked in the Indian Patent Act? See, controller is a part of the Indian Patent Act, and under section 73 it is written that the controller is appointed as per the section 3 of the Trademark Act 1999. So in that manner you need to remember the following deadlines, and I have already communicated you that you need to prepare notes. See that if you are preparing your notes, it will be very much easy for you to crack the patent agent examination. If you are not preparing the notes, you might having knowledge this time or for this period for 1 hour, but at the end of the day it will be not utilization of that hour. So prepare your notes. Whatever I am writing, whatever I am suggesting, whatever comes in your mind, just note it down. When you note it down, your mind gets actions that you need to remember it. So when mind remember, you are able to crack the examination. Okay, now next one is convention application. It's cool that if someone from the India wants to file a patent outside the India, so within how much month the window period is open. Suppose I file a patent today in India, the today is the date is 18th December 2021, and I want to continue it, means within in case of convention application, suppose I want to file it in a European country, so what is the period through which I can apply, within how much period I can apply for the convention application? It's 12 months. Very good, cool. Parag and Shalaka, really nice. Okay, the 12-month window period is open from the date of filing the first application with complete specification. Okay, so with complete specification, 12-month window period is there, but under which section the convention application is mentioned? Under which section? Can anyone not? Can anyone give the answer? Under which section the convention application comes as far as the Indian Patent Act 1970 is concerned? 135. 135 is the section number under which the convention application is mentioned. Really cool. Okay, what do you mean by national treatment? What do you mean by national treatment? The convention application means, what do you mean by national treatment? See the 134 section. Okay, the 134 section defines that who cannot apply patent in India or who are not going to be the owner in any case if he thinks fit to following category. मैं आपको वो बता देता हूँ that if the another country, if the another state or country is not giving a right to Indian person to be a part of that particular country's patent authority, means patentee, then for that country it is called bilateral treaty, and for that country in India any person from that country cannot be the assignee, cannot be the legal representative, or cannot be the owner of the patent as far as Indian country is concerned. So जो भी country national treatment नहीं दे रही है इंडियन पर्सन को वहां पर पेटेंट फाइल करने के लिए, उस कंट्री के कोई भी व्यक्ति यहां पर पेटेंट फाइल नहीं कर सकते, ना ही उनके असाइनी बन सकते हैं, ना ही उनके लीगल रिप्रेजेंटेटिव बन सकते हैं. दैट इज मेंशन्ड अंडर द सेक्शन 134. Okay, so that is the main thing. National treatment means the way in which the Indian persons are treated in order to file a patent in India. In the same manner, if someone else is filing a patent in India, they need to follow the same directions, or they will be treated as a same, in the same manner as the Indian citizen is treated. That is called the national treatment. And on that ground, the convention countries are formulated or construed. Can anyone give me the answer that how many countries are currently the part of the PCT? How many countries are currently the part of the PCT? How many contracting states are member of the PCT? Contracting states are member of the PCT. Can any guess? Okay, okay, okay. As far as the Google Baba is concerned, it is 154. You can search it out that how many contracting states are member of the PCT. Contracting states are the member of the PCT. As far as the Google Baba is concerned, it is 154. Okay. Now convention country. Convention country means the country which gives the national treatment, as I have already discussed. So that comes under which section? It is comes under the section number 133. That we need to remember. It is comes under the section number 133, and already discussed about the bilateral treaty. Now district court, as per the, this is not that much important, but if you want to remember the Code of Civil Procedure 1908, district court is formulated as per the Code of Civil Procedure 1908. Okay, let me remove this particular Erase only. Okay. Now let's again discuss with the exclusive license. Do you know what is okay. In case of exclusive license, let me ask you a question. Whether the patent holder, the name, the patentee, correct? Once the patent is granted, the person is called patentee. Whether after giving an exclusive license to someone, whether the patent holder remains or having the authority of the patent on his behalf or not, whether the patent holder will have any authority on his behalf or not. I think my question is clear, correct? हिंदी में पूछ लूं तो ऐसा है कि एक्सक्लूसिव लाइसेंस देने के बाद क्या पेटेंटी का कोई भी राइट रहता है उस प्रोडक्ट पे या उस प्रोसेस पे, यस और नो, फॉर दैट पर्टिकुलर पर्सन टू whom the exclusive license is given? No. Very good. Yeah, we are having a very good knowledgeable person over here. So that is the meaning of the exclusive license. Exclusive license is given in which after giving an exclusive license, once I have purchased an iPhone, then it's my iPhone, the exclusive rights are given to me, exclusive license is given to me, I can use it at any manner, I can't commercialize it, but I can use it for my purpose. So that is my privilege, that is my exclusive license given by that patent person to me. Okay. Now government undertaking. Next point is I need poll with A to E option. Only poll I will use it frequently during. Okay, that is my poll. Okay, just a minute. Okay, now government undertaking. G is omitted, and then next is government undertaking. Any department of the government. Secondly, any corporation of the government. And thirdly, any company which is wholly or partially financed by the government. If you prepared any undertaking with that particular company or that particular corporation or that particular department, that is called the government undertaking. See, government department, corporation prepared by the government, and any company or any subsidiary which is wholly or partially financed by the government. Any undertaking is prepared under these three categories, that is called undertaking from the government. High Court, in some countries it is state-wise, like Gujarat having Gujarat High Court, and in India there are many states, so many high courts will be there. But in some of the countries it is the Supreme Court. Can you tell me in which country it will be the highest court? That terms High Court, like in India we terms as a Supreme Court. So in which state or in which country the highest court is High Court? Can anyone having an answer? Okay, just for your information, in Australia the highest court is High Court. Or in government undertaking, I can write down department, corporation, and wholly or partially. If any company is financed by the government, that is called the, if you are taking any undertaking on behalf of the government, then it is comes under the government undertaking. See, here is Muralidharan madam is writing, Muralidharan sir or madam, I don't know, but Muralidharan ji is writing that, sir, when government portion is less than 50%, is it still considered as government undertaking? As far as the government undertaking definition is concerned, as far as the government undertaking definition is concerned, under the section 2(1) and under the subsection of H, it is clearly written that wholly or partially. So if partially is less than 50%, then again it is a part of the government. It is considered as a government undertaking. International application, those application which are followed by the PCT route, that is called the international application. Can anyone give the full name of the PCT? Can anyone give the full name of the PCT? What do you mean by PCT? What do you mean by PCT? Please give me the answer. It's very simple. Patent Cooperation Treaty. Very good. So, in case of convention country, in case of convention application, under section 135, the window period is 12 months. In case of convention application under section 135, the window period is 12 months. But in case of PCT, in case of international application, what should be the window period? What will be the window period? What will be the window period? 30 to 31 months. Excellent, excellent. Muralidharan ji, it is not a correct answer. 18 months is not a correct answer. You are confusing yourself with the publication and the PCT. So if one goes from the PCT route, he can file, he or she can have a window period of 30 to 31 months. And what is the main advantage of the international application or through the PCT route is one can file in multiple convention countries at a time. But in case of conventional application, one can file in many countries, but the window period is 12 months. Okay, okay, very good. And that for Muralidharan ji, for that purpose only this kind of lectures are arranged. Then you will get the clear idea about what to be remember or what to be not. Invention. Now the invention having and condition. I remember that part as an invention having and condition. Now what is and condition? What is and condition means the first condition needs to be met and also the second condition needs to be met. Then and then we can say that particular thing as invention. In case of Indian Patent Act 1917 under section 21J, the invention means which involves inventive step, and having industrial capability, yani capable of industry application. Capable of industrial application. If these two conditions met, then and then we can say it is an invention. If there is no use of industry, then it does not fall under the category of invention. Clear? Okay, now what do you mean by inventive step then? That might be the question. Now, inventive step, very important question. I must say, it's a star question. Okay, in case of inventive step having or condition. See, the invention having and condition and inventive step, the definition of the inventive step having the or condition means either or any of the condition needs to be satisfied. So what is the inventive step? There are two things which or condition, that technically advanced or economically significant. Technically advanced or economically significant or both. Then and then it termed as inventive step. Then and then it termed as inventive step. Many times while preparing the patent agent examination, patent agent are knowing that this term technically advanced and economically significant. But what you exactly you are missing, that is or condition over here and condition over here. If you read that particular thing in a careful manner, then you will realize, okay, this is and condition means both the condition need to be satisfied. In case of invention, it must having inventive step also industrial capability need to be there. But in case of inventive step, there should be or condition, either technically advanced or economically significant, or both of them. Legal representative, the direct owner of the dead person, that is called the legal representative of that particular patent. Okay, one thing is already omitted, that is new invention. In case of new invention or the novel, what do you mean by novel? What do you mean by novel? In the chat section, please answer. What do you mean by novel? What do you mean by novel? Can anyone write down in the chat section, what do you mean by novel?
Something that is not disclosed in a single document prior to the knowledge.
Never published in the worldwide. Never published in the worldwide. Never used in the worldwide before that particular invention exists. That is called the novelty or the new invention. That is one of the criteria of the patentability. Okay, opposition board. So opposition board, in the opposition board, one need to remember the one thing, that is when the opposition board is come into picture, when opposition board will come into picture, as per section 25 under the section subsection 3, it is clearly mentioned that the opposition board is constituted. But for what purpose? After grant of the patent published in the Indian official gazette, after the grant of the patent published in the official Indian gazette, if any person interested having an objection, he or she can file his opposition within 12 months, within a 12-month period from the date of publishment of grant of the patent. जब पेटेंट ग्रांट हो चुकी है, पेटेंट ग्रांट होने के बाद पब्लिश हो चुकी है ऑफिशियल गैजेट में, तो वहां से लेके जब पब्लिश हुई है वहां से लेके 12 मंथ के अंदर अंदर, इफ एनी पर्सन इंटरेस्टेड हैविंग एनी ऑपोजिशन, हैविंग एनी ऑब्लिगेशन, इफ ही फाइल्स अ opposition, then for that particular complaint, the opposition board is constituted. Okay, and that is mentioned under the subsection 3 of the section 25. Next thing is patent, an exclusive right given by the government to the patent to the person for that invention for the period of time which is 20 years in case of India. Patent agent, again already discussed in the first class, but again revising it. Eligibility as per the section 126 and rule number 109 and 110, out of which how many marks needs to be score, that is mentioned in the rule number 110. And in case of 126, it is written that who can become Indian patent agent, having an age of 21 years, Indian citizen, and pass out the degree from the degree in science from the any of the Indian university which is comes under the government review. Patented article, the article which is prepared as per the rules and Patent Act, that is called patented article. PCT, Patent Cooperation Treaty, as far as the Google Baba is concerned, still there are 154 countries are part of, or states are the part of PCT. Patentee, before grant of the patent, the person who has applied for the patent, that is called applicant. Before grant of the patent, if you file any patent, then you yourself is applicant for that patent. But once the patent is granted, once the official publication of that patent grant is published in the Indian Patent Gazette, then you become patentee. Patent of addition. After filing a patent, if someone feels that by adding a few more process, or by adding few more inventive steps, that particular patent can be extended, then in that case patent of addition can be granted. Patent of addition can be granted. And patent of addition comes under the section number 54. Section number 54. So in that case, what happens? If the patent of addition is granted, then what will be the benefit? The renewal fees need not to be paid, because it is a patent of addition, and patent of addition is granted. It means the additional patent which is granted, that is also lapsed with the main patent application or the first patent application. If in case the first patent application gets revoked, then the next one, or patent of addition, may be the separate patent and having the separate tenure as per the filing date of that patent. I think it will be difficult. Let me explain it in Hindi as well. सो पेटेंट ऑफ एडिशन एक ऐसी चीज है, अगर हमने पेटेंट फाइल कर दी और उसके बाद में हमें ऐसा लगा कि इस पेटेंट में थोड़ा सा मॉडिफिकेशन करके हम दूसरी पेटेंट फाइल कर सकते हैं, या फिर उसी पेटेंट के प्रोसेस या प्रोडक्ट को मॉडिफाई कर सकते हैं, तो वहां पर अगर हम पेटेंट ऑफ एडिशन फाइल करते हैं तो हमें रिन्यूअल फीस जो देनी पड़ती है पेटेंट की, वो नहीं देनी पड़ेगी। रिन्यूअल फीस के साथ साथ टेन्योर भी उसका जो मेन पेटेंट एप्लीकेशन है वहां से लेके रहेगा। पेटेंट ऑफ एडिशन, अगर मेन पेटेंट रिवोक हो जाती है इन सम केस, तो पेटेंट ऑफ एडिशन को सेपरेटली पेटेंट भी बनाया जा सकता है। ये जो प्रोविजंस लिखे गए हैं वो है सेक्शन नंबर 54, 55 एंड 56 में जो मैंने कहा वो। मगर आपके लिए समझना इतना है, अंडर विच सेक्शन द पेटेंट ऑफ एडिशंस कम, दैट लाइज अंडर द 54 सेक्शन। मैं आपको क्यों इस तरीके से बता रहा हूं, 54 को क्यों डिटेल में नहीं बता रहा हूं, बिकॉज ये डेफिनेशंस है, यहां से हमें इतना ही समझना है। फ्रॉम दिस डेफिनेशंस वी नीड टू रिमेंबर फॉलोइंग थिंग्स। वंस when someone is teaching you the section particular 54, 55, 56, at that time he or she will explain each and every part of it, so don't worry about every part. These are the old definition from the Patent Act, so each and every section is correlated with following statement, following definitions. But what is main thing, or what is what needs to be remembered, that is important. Okay, patent office as per the section number 74, patent office are considered. Okay, so again the complete 74 need not to be explained, but section number 74 will indicate where or how the patent office need to be considered, what are the responsibility of the patent office, and what it must function as far as the patent office is concerned. We all knows that for dealing with the different part of the country, the patent office are constituted, and for the as far as the Gujarat is concerned, my state is concerned, I need to put my application in the Mumbai West patent office. Okay, so in that manner the patent office are considered where the patent applications get gets controlled in that particular premises. Person, whenever you read person in the Indian Patent Act, remember one thing, it includes government as well. It includes government as well. So government is not a separate person. Person means it includes government. Okay, person interested. person interested having 3 criteria: either promoting, engage in that particular process or product, or in research of that particular product or process. Person interested means who is engaged in that product or process which is already granted. The person is in promotion of that product or process, and either the person who is dealing with the research of that process or product. See, person interested comes into the picture after grant of the patent. Before the grant of the patent, anyone can take objection on the published patent application. But once the patent granted, only and only person interested can take opposition. No one else can do the opposition on that particular granted patent if he cannot comes under this preview. Okay, and that is also for the window period of 1 year. And after the 1 year, if someone has not given any kind of infringement, then the patent can be revoked by the section number 64 as mentioned in the ground section in section number 64. Okay, next point is pharmaceutical substance. It includes one or more inventive steps, that is called the pharmaceutical substance. Next is prescribed. Prescribed means prescribed in terms of High Court, prescribed by this appellate board, and prescribed under this act and rule. So whatever written, that is called prescribed manner. It's a prescription from the doctor, like it's a prescription from the patent, prescription to the patent agent. Okay, next thing is true and first inventor. If I am a person from the India, if I get an information from the outside and I implemented that particular thing in India first time, I am not the true and first inventor. Or if some person in India giving some information to the outside person, so he is not also the first or true inventor. It simply means that if in any part of the world, if any information is in working, and for that particular process or product, if we are filing a patent which is already existed in the world at any place, so you are not the true and first inventor of that particular product and process. Correct? So all definitions are clear, and now it's a poll time. I think it took it took 57 minutes, but let's do the poll time. Now it's your time. You need to give answer all the questions, and if you give the correct answer, then it is okay. If you give wrong answer, I will give you the justification why it is wrong. Okay, the first question is, till which year there been an amendment in the Patent Act? 1995, 2021, 2017, and 1999. Give the answer in the chat section. Perfect. Okay. Again, 1999 one answer, 2021 one answer. I have already started my lecture with this particular thing.
2017.
That's 2017. And can you give me the date, exit date?
23/6/2017.
Perfect. Okay. Let's have the another question. Any doubt in this question? I think no doubt will be there. Okay. Next question, please. Appellate board established in which year of the act?
Javier, just one thing.
Yes.
You mentioned something in the same year, April. I missed that part.
Where?
Something April, you also mentioned.
April.
April 2013 or 2017?
No.
that's okay.
At the starting of the lecture, I have written this act, that is
Yes, yes.
23rd 6 2017.
Yeah.
Might be if
Okay.
I'm wrong, then this is the correct date.
Sure.
But I think I have written this because I have already prepared a notes for that purpose.
Yeah, okay.
Okay.
No problem.
But the answer is 2017. और ये कहाँ से आपको मिलेगा ये आंसर? In order to justify this answer, if you need a proof of this answer, you can go to the Indian Patent Act and go with the Patent Act date. This question is related to section number 1. Okay.
Sir,
Yes, please.
so in continuance with the question that is just asked,
Yes.
so when you were discussing section 1, you told
Yep.
us to visit the website IP India, and then you mentioned this date, 23rd, this June
Yep.
2017, right,
Yep.
sir? But sir, the Patent Act came into force on which date? This day, this is not the date, right?
I'm not
It-
saying came into force.
I'm asking you. It came into force on 20th April 1972.
True, sir. It's true.
Okay, so when you mentioned this date, when you were discussing section 1, you were implying that the last amendment took place on this date, right, sir?
Yes, sir. That is the question. Till which year there been an amendment in the Patent Act? I think the question is also the same.
Okay, so now it's clear. At that time, I was having this doubt why
Okay.
this date was mentioned.
No
Okay,
worry.
thank you, sir.
It
Thank you.
might be possible because of my incorrect grammatical statement.
No,
So
no.
might be possible.
I was not able to comprehend. Thank you.
Okay, sir. It's okay. But now it is clear, correct? Okay. That's great.
So in 1970 also we do have some specific date.
Hello.
Mm.
I will give you the proof. If there is a confusion, let it be first. First, clear this 30
In
questions.
1970 when it came into effect. In that year also we do have any sure.
That we will look out, sir. Don't worry about it. It's only one question. Let complete 29 more questions that have the discussion on that point also. Because each and every discussion will open your mind, will able to remind you for the last month. अगर आप ऐसे ही डिस्कशन करेंगे ना तो आपको बहुत अच्छी तरीके से ज्यादा याद रहेगा. That is my surety. मैंने भी बहुत टाइम जब मैं पेटेंट एजेंट की ये एग्जामिनेशन दे रहा था, I used to ask questions like anything. आपको पता है, चलिए आप कैन यू गिव मी द आंसर? ये जो पेटेंट हमने फाइल की है, पेटेंट कब से फाइल करना हमने स्टार्ट किया है? फ्रॉम विच ईयर वी हैव स्टार्टेड फाइलिंग अ पेटेंट इन इंडिया? From which year we have started filing patent in India through patent office? Suppose 2005. Okay, whatever will be the year. But before that, 2005, the period is 1995 to 2005. करेक्ट? ये पीरियड के बीच में पेटेंट्स कहां पर फाइल है और वो पेटेंट्स अगर फाइल है तो वो कहां पर अवेलेबल है? Can anyone give the answer? I think the answers are available. Hello. Am I going out of the box? Okay, let me complete this 29 question and then I will discuss over this point also, and also we will find out the correct answer of the 1971. Correct? So just give me few minutes, please. Appellate board established in which year of the act? 1995, 1999, 2017, and 2021. Answer, please. Perfect. Please mention the section number and which act it is. Please mention the section number and which act it is. Trademark Act section. Perfect. Superb. Now that's what I call learning. Okay, appellate board established under which section of the Patent Act? Already answered. The answer is but the options are not given in that manner. The answer is correct, 116, but the options are not given in that manner. So under the which section of the Patent Act, the answer is 116 might be, but if the options are given in that manner, then 83 section of the Trademark Act 1999. So Patent Act, if I am writing Patent Act, so it is wrong question. Which section of the act? The answer is 83 of the Trademark Act 1999. Okay, question number 4. Who can become a member of the appellate board? Answer please. Who can become a member of the appellate board? Super, 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 super. 110% correct. Next question, please. Budapest Treaty adopted in which year? Might be the interesting question because I have not discussed it in the at that time when I am discussing this part. Budapest Treaty. Can anyone knowing that particular answer? Very good, yeah. It's 1977. It's 1977. Okay, but I have not discussed at that time, so sorry for that. But the answer is 1977. Next question is CGPDTM. Please give me the full form of the CGPDTM. What is the full form of the CGPDTM? Yes, true. True. CGPDTM full form, please. Fast. We are having 30 questions and I need to complete it. Budapest Treaty. Perfect. Controller General of Patent, Design and Trademark. Okay. Appointed under. Answer please. What happened? Answer please. B.
Section 1.
You can write down your answer in the chat section. I'm able to see the chat section. Question 6. Section 83 of the Trademark Act. We have already discussed section 83 of the Trademark Act is related to appellate board. Why you are giving the answer in that manner? See, section 3 indicates what is not patentable. That is very much easy. I have already formulated this the question. When I preparing the options of that questions, then I know that the persons, those who are attempting the patent exam for the first time. So in that manner, I have prepared the questions. If you are using your common sense, you are able to give the correct answer. Section 3 relates to non-patentability. Section 1 is a short title. Section 83 of the trademark relates to appellate board, and section 3 is the remaining answer which relates to controller. Clear? If you are having any doubt, please unmute yourself and ask doubt for this particular question. I think Parag is most active person over here. Parag, do you have any doubt?
No, sir, we can continue.
Okay, thank you. See, controller referred in which section of the act? Very
73.
much simple. It's very much simple. Controller referred in which section of the act? 73. Very well, very well, very well. This is wrong answer because it's a short title. Second is a definition part. Third one is a non-patentability. 73 is the only option which is correct answer. Next. Which section relates convention application? Which section relates to convention application? 135, 73, 1, and 2. Convention application 135. Very good. 73. Controller. 1. Short title. 2. Definition. In that manner, you need to recall your answers. So whenever you are preparing for the patent agent examination, also at that time, why the other 3 options are not correct, that must be known to you. In that manner, you need to prepare your examination. You need to prepare yourself for the examination. Which section relates to convention countries? 133, 135, 73 or 2? 133. ओके, मुरलीधरन जी ने आंसर दिया है, पराग जी ने आंसर दे दिया 134. 134 relates to convention countries. Have you gone through the 134? पराग जी 134 में क्या है, चलो वो भी डिस्कशन वापस एक बार कर लेते हैं. 133 is the correct answer. 135 relates to convention application, 73 relates to controller, and 2 relates to definition. That's why it is wrong answer. 134 में क्या आंसर था? 134 किसके लिए था? Can anyone recall for what purpose 134 section is there?
National treatment.
Yes, please, one by one. 134 section किसके लिए था?
It was for national treatment.
Yes, अगर कोई और कंट्री हमें नेशनल ट्रीटमेंट नहीं देती है तो इंडिया भी उस कंट्री को नेशनल ट्रीटमेंट नहीं देगा. रेसिप्रोसिटी. मगर मुझे वो वर्ड, I am not able to remember those words like reciprocity, so I prepared my own definition of it, that if any of the country from any part of the world, if that country is not treating the Indian person as their national treatment, as per their national treatment, then India will not give any privilege to that country's citizen in India for a patent purpose to have such kind of privilege, national treatment. Okay, so that is the reciprocity which is mentioned in the section number 134. Which section defines exclusive license? Oh, great. Which section defines exclusive license? Please tell. Now this question will hamper you at some point. C is the correct answer. Okay. C is the correct answer. Okay. What is 2J? 2J stands for which definition? 2J stands for which
Invention.
definition? Invention, correct. 2AB refers to which?
Assignee.
Correct. Second, assignee. And 2C refers to which?
Convention application.
Perfect. Question number 11. Government undertaking means by department of the government, by corporation established by a central, by institution wholly or substantially financed by the government. There is nowhere written it is less than 50 or more than 50. Substantially financed by the government. All of them?
All of them.
Correct answer. Chat section, please be active. It is very much clear that when I am teaching to someone, it will not create such kind of interest when I am asking such kind of questions out of it, because by the way of questions you are able to visualize that what kind of questions can be asked in the patent agent examination. Sir, can you please point C? Yes, why not? Point C is written by an institution wholly or substantially financed by the government. Substantially financed. Now, How to measure substantially finance? Already there is a question at the time of while discussing about this point. Substantially means what? It can be substantially means 49% of stakes, 30% of stakes, 50% of stakes, but not in a minor stake. Whatever will be the stake. Right now, as per this definition, we are saying that it is a part of the government, and if is there any undertaking related to that particular institution with your patent, then it is called government undertakings. Okay. Next. Question 12. Window period for convention application. Answer
12
please.
months.
12 months.
Very good, very good, very good. Okay, and in case of convention application, I forgot one main thing, that that person needs to submit the certified copy of that patent application. Okay, so remember that within a 12-month in the another convention country, not only you need to file that particular application over there, but you need to submit your certified copy through which that is called base application, and based on this base application your priority date will be given. Okay, so that is the another point that I recall right now. 12 month is the correct answer. This answer are related to PCT. 12 month is the correct answer. 24 months, nowhere it is mentioned. Window period for PCT application. Oh,
30 to 31.
30 to 31 months. And when someone refers to PCT application, when he or she wants to file more than one country, in more than one country, at that time one can go for the PCT application. If one wants to file in only one country or two countries, then he can go with the convention application route as well.
But how do we see this question? Can you go back to question, please?
Yes.
So in this case, a person can also file in 12 months, right?
Yes.
So
But-
it's both of them can also be
No,
an
no,
answer.
no, not at all. The both of them, window period for PCT application is 31 months. How can be the window period?
So
will
the
be
entire
12
window period, yours.
Entire window period, yes.
Okay. Yeah,
Means
got it.
throughout the PCT application route, how one can file a patent. This is
Yeah.
These questions are created by myself through my thoughts. So it might be not perfect that much, but it will give you the glimpse how the questions are generated when you are preparing for your examination. How you need to prepare, how you need to generate your questions while reading the statements or reading the any kind of definitions over there. Okay. Invention means 2J. Invention means 2J.
Both of them.
Very good. Why? May I ask why?
And it should
And
be
condition. Perfect. Inventive step and capable of industry application. Then it is called invention as far as Indian Patent Act is concerned. Patent of addition means patent granted in accordance with section
D, section 54.
Okay. I'm waiting for the other persons to answer.
54 section.
54 section.
Sure. Okay. 73 relates to whom? 73 relates to whom?
Controller.
Controller. 133.
Convention country.
Convention country. Very good. 135.
Convention application.
Convention application.
Application.
See, यहाँ पर आपको कंफ्यूजन होगा. कन्वेंशन कंट्री पहले आती है, एप्लीकेशन बाद में आती है. कंट्री comes first, application then can be filed. In that manner, you can remember 133 comes first, then comes 135, and 134 says who cannot be a assignee, be a legal representative, or become a true and first inventor or patentee in India. कन्वेंशन कंट्री की बात करता है 133 सेक्शन. 134 सेक्शन बता रहा है कि जो कन्वेंशन कंट्री नहीं है उसके साथ क्या होगा, एंड 135 सेज कन्वेंशन एप्लीकेशन कैसे करनी है. एंड 54 इज द करेक्ट आंसर फॉर द पेटेंट ऑफ एडिशन. नेक्स्ट क्वेश्चन 16. पेटेंट ऑफिस रिफर्ड इन विच सेक्शन?
74.
74.
74. परफेक्ट. अगेन यहाँ पर 135 क्या लिखूं? 135 में मैं what should be written
Convention
in
application.
135?
Convention application.
वन कन्वेंशन एप्लीकेशन. आप ऐसा सोच रहे होंगे कि सर बार बार ये क्वेश्चन क्यों लेके आ रहे हैं, बार बार 135 क्यों लेके आ रहे हैं. एट द एंड ऑफ दिस लेक्चर यू विल realize that by putting such kind of point, by making it simple for you, you are able to remember it for last long. 54 is
Patent of
Patent
addition.
of addition.
73 is for,
Controller.
and 70 is for.
Patent
Patent
office.
office.
In the same manner, in the same manner as we remember the patent, convention application and convention country. Convention country comes first, and then applications to be filed. In the same manner, we can remember the controller comes first. When the controller is appointed, patent office can be established. Without controller, nothing can be controlled in the patent office. Person interested includes.
Person engaged. All of the above.
All of the above.
You need to remember. Okay, I'm waiting for the more answers. Please be attentive like these two persons. If you are more attentive, you definitely going to have advantage of it.
Jasveer Saab,
Yes. Any
can
question?
you give examples of questions which have multiple answers for the same question?
I can generate it, but as it is a first class and I don't want to generate right now for the first class person. But at that time, when we are having the next class, I have already discussed with these persons, and I need to prepare one more test for you. So at that time, the level of the questions must be higher. Correct? I
Okay,
think the answer
okay,
is clear.
thank you.
Okay. But the person interested means who is engaged, promoting, or person in research in the same field. So the correct answer is
All of the above.
okay. There will be more option, none of the above. Question 18. Inventive step means. Inventive steps means.
C, both.
Both.
ABC, all of the above, sir.
All of the above.
Yeah.
All of the above, all of the above. Because
That
it's
is
or
true.
and both.
See that. See, this is the beauty of learning. See, this is the beauty of learning. Technical advancement or economical significance or both. So all the three answers are correct. So the answer correct is D. In this case, inventive steps. अगर अच्छा लगा है तो लाइक कर दीजिए, थम्स अप दीजिए. ये क्वेश्चन तो थोड़ा सा आपको डिफिकल्ट लगा, मुझे लग रहा है ऐसा, और कुछ आपको लगा भी कि नहीं सही में ऐसा क्वेश्चन हो सकता है, थम्स अप दे दीजिए प्लीज. ओके. Inventive steps comes under which point of the section 2.1? A, B, C, D, which alphabetical order?
J,
JA.
A. Okay, so that is also it should be justified. Okay. Priority date referred in which section of the Indian Patent Act? This is not discussed, but still also if you are preparing for the examination, then this is really need to be known by you.
C.
11.
11. Okay, 73 refers to
Controller.
Controller.
74 refers to
Patent office.
Office.
2 refers to definition and
Definition.
11 is the correct answer. Priority date referred in which section? It is in under the section number 11, and under the section number 11 that is also written that one can file provisional application, and after 12 months one can file the complete specification. But after filing the provisional the specification, and priority date will be given in respect of the provisional specification in that case. Okay, question number 20. Register of patents referred to in section number
67.
67.
Okay, perfect. I think some definition might skipped it out. That's why these are the final 3-4 points of the definition. The register of the patent, which contains the patentee name, their address, and their the register of patents also contains some information. Okay, let me give you the idea about it. Name and address of the patentee is given under the register of the patent. Then assignment, extension, revocation, assignment, extension, revocation, that all kind of documents comes under the register of the patent. And if anything that defines the validity or that change the validity of the patent, that comes under the register of patent as far as the register of Indian Patent Act is concerned. 73 relates to controller, 74 relates to patent office,
Patent office.
54 relates to
Patent of addition.
Addition.
patent of addition. Very good. And 67
Atom
relates
capital.
to
Okay.
register. Okay. Question number 21. How many contracting states are member of PCT? This answer is as per Google, so don't go with it. But what I already searched, that is written here. It is 154. Very good. But this is a Google answer. You can check it out. You can surf it on a Google. You will get this answer. This is not under the Indian Patent Act. This is only a question for general knowledge. Don't go with that. An application for a patent for an invention may be made by कौन कर सकता है एक इन्वेंशन के लिए? Who can file a patent?
Person claiming to be true and first invention.
First invention.
All of them. All of them.
By any person claiming the true and first invention, by any person who is the assignee of that person, by the legal representative of
अभी कैसे लेके जाएंगे? कुछ अच्छा बोलो या फिर बोलो।
Hello.
खराब हो जाते हैं।
Okay, it's D, all of the above. Correct? Is there any question? Anything else? Okay.
Can you
Question number
please
20.
explain the last one?
Yes,
The
yes. Why not? Why not? An application for a patent for an invention may be made by. किसी ने अगर कोई invention किया है, if someone did any invention, if I or any person had generated any product or process that can be invented, that can be patented, who can file a patent on his behalf? By any person claiming to be the first and true inventor, means by himself, by any person being the assignee of that person, and by the legal representative of the any deceased person if that person is already dead. Is it okay now?
Yes, okay, yeah, got it. Thank you.
Question number 23. If any country not giving national treatment to India, then no person from that country can file patent in India. Statement relates to which section? Statement
134.
relates to
134.
134.
वेरी गुड वेरी गुड। देखिए अगर मैंने इस तरीके से डेफिनेशन आपको नहीं देती है, अगर नहीं दिया होता ना, आप 134 पढ़ लीजिएगा तो आपको कंफ्यूजन रहेगा। बट इफ यू क्रिएट योर ओन डेफिनेशन, मैं अपनी तारीफ नहीं कर रहा हूं, बट इफ यू क्रिएट योर ओन डेफिनेशन देन it will be beneficial for you to give answer. Now whenever that point comes in your mind, if some country is not giving such kind of national treatment to Indian person, then definitely that comes under the 134. डेफिनेशन तो आपने भी बनाई होगी, बट डिस्कशन से आपको सेक्शन नंबर याद रहते हैं, ये इंपॉर्टेंट है। 73 relates to what?
Controller.
Controller. Okay. 3 relates to non-patentability.
Non-patentability.
Okay. 6 relates to
Person entitled to apply for patent.
patent. देखिए 134 and 6 का contradiction है। 134 says who cannot apply. 6 says who can apply. Who can apply? That is already discussed in the question number 22. Question number 22 जो था कि that person can apply for the patent, that assignee of that person and legal representative of that person, that is mentioned under the section 6. Okay, so question number 2 जो मैंने यहाँ पर लिखा था, that is related to question 6, who can apply for the patent. 24, person interested may give notice of opposition to controller. Opposition board से ये question लिया गया है। Opposition board अगर आप, this question came from the opposition board. Under the opposition board, opposition, yes.
Answer C, sir.
Answer C, perfect. But that relates to which section? That relates to
25,
which section?
subsection 3.
25, but subsection 2, my friend. This timeline is mentioned under the subsection 2, not under the subsection 3. Under the subsection 3, it is mentioned that if such kind of infringement is given after the grant of the patent, then opposition board is going to be constructed on that basis. Okay.
Can you state the difference between 2 and 3 again?
That is also that is the same thing. 25(1). 25 gives the opposition ground, list of opposition ground from A to K. Remember, 25(1) gives opposition ground from A to K. There are many grounds through which one can do opposition. Okay. After grant of the patent, means this is before the grant of the patent. After grant of the patent, suddenly person interested came into picture. And person interested can do one thing, that after grant of the patent, within 1 year, he can file opposition in the prescribed format.
Yes.
Okay. And if he do so, he or she do so, person interested do so, then opposition board is going to be constructed, that is mentioned in the 25(3). Then what going to be happen? Then opposition board is going to be constructed by the controller.
Okay.
That is mentioned in the 25(3). Don't take much more information right now, but these are the glimpse of the 25th Act. If you go into the detail of the 25th Act, you will get this kind of glimpse out of it.
Yes. Okay, thanks.
Okay. Opposition board constitute under
C.
B.
C.
C,
I have
C.
already prepared the question in that manner only. कि मुझे ऐसा लग रहा था कि when I put question number 24, then such kind of questions will ask. So that question comes in my mind, and that I created one question out of it. So 25(1) A to K ground, 25(2) person interested, the limit of 1 month, 1 year is mentioned over there, and 25(3) opposition board is the correct answer. (26) question, minimum marks to be obtained in order to become patent agent mentioned in which rule? This is a revision question. Last 3-4 questions are revision or revision questions, nothing else.
110.
Yes.
110.
C.
It's rule number.
Rule
Yes,
10.
C. While discussing this
109.
part, I already mentioned the correct wrong thing, na? 110. Okay, it's 111. I think so. Just a minute. Okay, I will check it
10.
out. It's 111. I think so. 111. Patent Act. Let's discuss it thoroughly. I'm little bit confused about 110 and 111, in which the minimum marks is given. I will give you the answer of this question later on. But
It's
as far as
109, sir.
yes,
111,
Not
sir.
9.
111, correct? The percentage
111.
marks. Okay. Question number 27. Eligibility of patent agent examination mentioned in which section of the Patent Act?
126.
126.
135 relates to
Convention application.
Convention
Application.
25 relates to
Opposition.
Position.
73 relates to
Controller.
Controller.
patent of addition means patent granted in according with which section?
54.
54.
54.
Patent of
54.
addition. 2 is definition, 3 is controller, and 25 is opposition. 29. Patent office means the patent office referred in section
74.
74.
74.
73. Controller.
Controller.
74.
Once governed, then patent office can be open. Section 3.
23. What
Not patentable
not
invention.
patentable invention.
And 25. Opposition.
Position.
Priority date has the meaning assigned to it by section number
11.
11.
3. Not invention.
Non-patent
25.
invention.
Opposition.
Opposition.
And 54.
52. Patent granted and patent of the
Addition.
addition.
So with this question, I'm ending my presentation. I'm open for the question answer session. Let's end this session. And thank you very much for such interactive sessions. सभी लोगों ने बहुत अच्छी तरीके से participate किया. And 1 या 1.5 घंटे के लिए 2 घंटे और 1.5 घंटे हो गए. So मुझे bear किया for that purpose. Thank you very much for that patience. Okay, question please.
David, like I said, I'm going back to the same question. Like you mentioned, the amendment was made in 2017, right?
Yep.
Last amendment. So in the same way, when the act first proposed in 1970, was there any specific date? And if at all, any question asked in previous years over this?
Okay. So you said that what is the main date
In
from which
1970.
the
Yeah.
the patent act come into force?
Yes.
Into force, correct?
Yeah.
Okay. I will go into the detail of that question. I will find out the correct answer with the proper proof of it, and I will submit it to Bridges ji. Okay.
Sure.
That is the one question. Next question, any?
Yes, sir. So if you allow, sir.
Yes.
So with
why not?
regards to, as we were discussing rule 110 and 1111,
Yep.
I believe it's in rule 110 that the marks that are being mentioned.
True. That's why I confused, because
Yes, yes,
in my
yes.
mind also it's 110, not 111. Correct? In 111 it is mentioned something like
Registration of the patent agents.
yes, true. In 110 the definition is given. From the first paper you need to give 50% marks. Okay, just a minute. We will clear this doubt in front of everyone. That is also a process of the learning. Okay, so just a minute. I need to share my screen. How can I share? Screen. Okay, screen share. Now you are able to see my screen. I need to escape from this particular point. Okay, keep. Hmm? Under rules, see, whenever you are referring these rules, actually it is very much clearly mentioned in the paper 1 book, which is presented by the ISER India Limited. But whenever you are referring from this site, make sure that you refer from this 2021 particular rules. And under that section, let's see the 110 section, rule number. Application for the registration of the patent particulars. Yes, particulars are mentioned in the rule number 110. Perfect. 100% sure about it now. Okay, next question, please. Is there any question, friends? Hello. I think there is no question, and I end up with the one question. Thanks for enlightening the session, such sessions in future CGPDTM. So do you want the full form of the CGPDTM? Shashi? Will you explain? Yes, it's a controller under the section 73. Let's define that point once again. No worry about it. It's open, not open. 67. Just a minute, I will explain it out. (68, 69, 68, 69, 70, 71, 72, and 73. As per the section 73, under the subsection 1, the definition of the Controller General of Patent, Design and Trademarks are given, appointed under the subsection 1 of the section 3 of the Trademark Act 1999, 47 of 1999 shall be the Controller of Patent for the purpose of this Act. For the purpose of this Act, Central Government may appoint. Central Government यहाँ पर appoint करती है many examiners and other officers and with such designation as it thinks fit. तो यहाँ पर जो भी एग्जामिनर है और जो भी ऑफिसर्स है उनसे जो काम निकलवाना है, उनसे जो पूरा प्रोसेस कंप्लीट करवाना है, पेटेंट की डेडलाइन कंप्लीट करनी है, that work is need to be controlled by whom? The whole responsibility is tends to the shoulder of controller. I think it is clear now, the basic definition.
Sure, David. So you're saying that there will be only one controller for each patent office? We have 4 controllers altogether in India.
True.
Okay. Thanks for that.
Next. Sir, can we discuss on the IPAB abolishment and latest development? Yes, that is also a part of the syllabus. This is the first lecture, Devarajan Ji. This is the first lecture, and in this lecture we have discussed about the section 1 and section 2, and there is a plenty of lectures, lecture series are there in this platform, and you can attend those series, and under that series I 100% assure you that this IPAB abolishment and latest development like students startup policies and everything that you are talking about, that is covered under it. So far I think I delivered my best. That is from my side.
Yeah, thank you.
Thank you very much for your time and concern. Is there anything, any person from the IAS, ER, India Analytics? Can you repeat section 1 last point once again? Why not? That's fine. Thank you for interest. Okay. I am going to repeat the last point of this section 1. That is what required over here. See, for me, if there is a discussion, if there is such kind of curiosity from the student side, so I really I'm very talkative person, and I really enjoyed that. This is my real work, this is my real appreciation, that at the end of the session also someone wants to remind something, like you have written something in the first slide that I want to recall. So in the first slide it is written that, oh, this is from the last point. Okay, I can show it here. Okay, as well. Provided that different dates may be appointed for different provision of this act, and any reference in such provision to that commencement of the act shall be construed as a reference to the coming into force of that provision. इसका मतलब मीनिंग होता है बेशर्त कि इस अधिनियम के विभिन्न प्रावधानों के लिए अलग अलग तिथियां नियत की जा सकती है। जैसे कि सेक्शन 1 सपोज अमेंड करना है, सेक्शन 1 में तो ज्यादा कुछ नहीं है, बट सेक्शन 2, 3, 4, 5, 6, 7, 8, 9, 10 कुछ भी अमेंड करना है तो उसके लिए अलग अलग डेट दी जा सकती है। और इस अधिनियम के प्रारंभ के लिए ऐसे किसी प्रावधान में, किसी भी संदर्भ में, संदर्भ को उस प्रावधान के लागू होने के संदर्भ के रूप में माना जाएगा। सो द डेट ऑन विच इट इज ऑफिशियली अनाउंस्ड, दैट इज द डेट came into force for that particular amendment, that is written here from their side. I think this much will be the explanation from my side. I don't know what is your exact question out of this. Sri,
So if there is amendment, for suppose if there is amendment in 2020, and
Yep.
if we have filed an opposition on which the filing is from 2018 or 2017, okay, so the
no,
force
no,
that will
no,
come in
new amendment will not act on
will
that.
not act on that. Okay, yeah, okay, thanks.
Okay, thank you very much everyone. Should I end this session, please?
Thank you.
Okay, and one question I will give the answer of the first question, that from which date the patent act come into force. With the proof I will send it to Bridges sir. Okay, so any person from the ISERD India representative are there? Can I end this session, sir? I need your green signal or red signal for stopping this one. I think they checked me. Many thanks, sir. The manner in which you explained the section was very helpful. Thank you. Thank you very much for such kind of comment. Okay. I think I end this session. Okay. Thank you. Thank you, everyone.